Now, let me just end with a couple observations about Mr. Cipollone's comments. He says, this is no big deal. We're not talking about when we're going to have witnesses or if we're going to have witnesses. We're just talking about when. Just talking about when. As if, well, later they're going to say, oh, yes, well, we're happy to have the witnesses now. It's just a question of when. Okay. As my colleague said, let's be real. There will be no when. There will be no when. Do you think they're going to have an epiphany a few days from now and say, okay, we're ready for witnesses? No, no, their goal is get you to say no now, get you to have the trial, and then argue, make it go away. Let's dismiss the whole thing. That's the plan. A vote to delay is a vote to deny. Let's make no mistake about that. They're not going to have an epiphany a few days from now and suddenly say, okay, the American people do deserve the answers. Their whole goal is that you'll never get to that point. You'll never get to that point. When they say when, they mean never. I yield back.
The majority leader is recognized.
I make a motion to table the amendment and ask for the ayes and nays.
Is there a sufficient second? There is. The clerk will call the roll.
Mr. Alexander.
Aye.
Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Mrs. Blackburn. Mr. Blumenthal. Mr. Blunt. Mr. Booker. Mr. Bozeman. Mr. Braun. Mr. Brown. Mr. Burr. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Mr. Enzi. Ms. Ernst. Mrs. Feinstein. Mrs. Fisher. Mr. Gardner. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Ms. Harris. Ms. Hassan. Mr. Hawley. Mr. Heinrich. Ms. Hirono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Inhofe. Mr. Johnson. Mr. Jones. Mr. Kane. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Lankford. Mr. Leahy. Mr. Lee. Mrs. Loeffler. Mr. Manchin. Mr. Markey. Mr. McConnell. Ms. McSally. Mr. Menendez. Mr. Merkley. Mr. Moran. Ms. Murkowski. Mr. Murphy. Mrs. Murray. Mr. Paul. Mr. Perdue. Mr. Peters. Mr. Portman. Mr. Reed. Mr. Risch. Mr. Roberts. Mr. Romney. Ms. Rosen. Mr. Rounds. Mr. Rubio. Mr. Sanders. Mr. Sass. Mr. Schatz. Mr. Schumer. Mr. Scott of Florida. Mr. Scott of South Carolina. Mrs. Shaheen. Mr. Shelby. Ms. Sinema. Ms. Smith. Ms. Stabenow. Mr. Sullivan. Mr. Tester. Mr. Thune. Mr. Tillis. Mr. Toomey. Mr. Udall. Mr. Van Hollen. Mr. Warner. Ms. Warren. Mr. Whitehouse. Mr. Wicker. Mr. Wyden. Mr. Young.
Are there any senators in the chamber wishing to change his or her vote? If not, the yeas are 53 and the nays are 47. The amendment is tabled.
Mr. Chief Justice,
Mr. Majority Leader is recognized.
I would ask consent to ask the Democratic leader, since there's a certain similarity to all these amendments, whether he might be willing to enter into a consent agreement to stack these votes.
Without objection, the inquiry is permitted.
Thank you, Mr. Chief Justice. The bottom line is very simple. As has been clear to every senator and the country, we believe witnesses and documents are extremely important, and a compelling case has been made for them. We will have votes on all of those. We will also, the leader, without consulting us, made changes, a number of significant changes that significantly deviated from the 1999 Clinton resolution. We want to change those. So there will be a good number of votes. We are willing to do some of those votes tomorrow. There's no reason we have to do them all tonight and inconvenience the Senate and the Chief Justice. But we will not back off on getting votes on all of these amendments, which we regard as extremely significant and important to the country.
As I've said,
Consent was for a question.
as I've said repeatedly, all of these amendments under the resolution could be dealt with at the appropriate time. I suggest the absence of quorum.
The clerk will call the roll.
Mr. Alexander.
Mr. Chief Justice,
Majority Leader is recognized.
I ask consent that further proceedings on the quorum call be dispensed with.
Without objection, so ordered.
Mr. Chief Justice,
The Democratic Leader is recognized.
I send an amendment to the desk to subpoena certain documents and records from the Department of Defense, and I ask that it be read.
The clerk will report.
The Senator from New York, Mr. Schumer, proposes an amendment, number 1288. At the appropriate place in the resolving clause, insert the following section. Notwithstanding any other provision of this resolution pursuant to Rules 5 and 6 of the Rules of Procedures and Practice in the Senate when sitting on impeachment trials, 1, the Chief Justice of the United States, through the Secretary of the Senate, shall issue a subpoena to the Secretary of Defense commanding him to produce, for the time period from January 1, 2019 to the present, all documents, communications, and other records within the possession, custody, or control of the Department of Defense referring or relating to A, the actual or potential suspension, withholding, delaying, freezing, or releasing of United States foreign assistance, military assistance, or security assistance of any kind to Ukraine, including but not limited to the Ukraine Security Assistance Initiative, USAI, and foreign military financing, FMF, including but not limited to 1, communications among or between officials at the Department of Defense, White House, Office of Management and Budget, Department of State, or Office of the Vice President. 2, documents, communications, notes, or other records created, sent, or received by the Secretary Mark Esper, Deputy Secretary David Norquist, Undersecretary of Defense Elaine McCusker, and Deputy Assistant Secretary of Defense Laura Cooper or Mr. Eric Tuning. 3, draft or final letters from Deputy Secretary David Norquist to the Office of Management and Budget. And 4, unredacted copies of all documents released in response to the September 25, 2019 Freedom of Information Act request by the Center for Public Integrity, tracking number 19-F-1934. B, the Ukrainian government's knowledge prior to August 28, 2019 of any actual or potential suspension, withholding, delaying, freezing, or releasing of United States foreign assistance, military assistance, or security assistance to Ukraine, including but not limited to all meetings, calls, or other engagements with Ukrainian officials regarding potential or actual suspensions, holds, or delays in United States assistance to Ukraine, including but not limited to 1, communications received from the Department of State concerning the Ukrainian embassy's inquiries about United States foreign assistance, military assistance, and security assistance to Ukraine, and 2, communications received directly from the Ukrainian embassy about United States foreign assistance, military assistance, and security assistance to Ukraine. C, communications, opinions, advice, counsel, approvals, or concurrences provided by the Department of Defense, Office of Management and Budget, or the White House on the legality of any suspension, withholding, delaying, freezing, or releasing of United States foreign assistance, military assistance, and security assistance to Ukraine. D, planned or actual meetings with President Trump related to United States foreign assistance, military assistance, or security assistance to Ukraine, including but not limited to any talking points and notes for Secretary Mark Esper's planned or actual meetings with President Trump on August 16, August 19, or August 30, 2019. E, the decision announced on or about September 11, 2019 to release appropriated foreign assistance, military assistance, and security assistance to Ukraine, including but not limited to any notes, memoranda, documentation, or correspondence related to the decision. And F, all meetings and calls between President Trump and the President of Ukraine, including but not limited to documents, communications, and other records related to the scheduling of, preparation for, and follow-up from the President's April 21 and July 25, 2019 telephone calls, as well as the President's September 25, 2019 meeting with the President of Ukraine in New York. And 2, the Sergeant-at-Arms is authorized to utilize the services of the Deputy Sergeant-at-Arms or any other employee of the Senate in serving the subpoena authorized to be issued by this action.
The amendment is arguable by the parties for 2 hours, equally divided. Mr. Manager Schiff, are you a proponent or opponent? Mr. Cipollone?
Mr. Chief Justice, we are an opponent.
So, Mr. Schiff, the House managers can proceed first and reserve time for rebuttal.
Mr. Chief Justice, the House managers will be reserving the balance of our time to respond to the argument of the Counsel for the President. Mr. Chief Justice, Senators, Counsel for the President, and the American people. I'd like to begin by getting something off of my chest, something that's been bothering me for a little while. Counsel for the President and some other folks in this room have been talking a lot about how late it's getting, how long this debate is taking. It's almost 10 p.m. in Washington, D.C. They say, let's get the show on the road, let's get moving. And the whole time, the only thing I can think about is how late it is in other places. Because right now, it's the middle of the night in Europe, where we have over 60,000 U.S. troops. There are helicopter pilots flying training missions, tankers maneuvering across fields, infantrymen walking with 100-pound packs. And yes, Ukrainian soldiers getting ready to wake up in their trenches, facing off against Russian tanks right now. And I don't think any of those folks want to hear us talk about how tired we are or how late it is. We have time to have this debate. And that's why the House managers strongly support this amendment to subpoena key documents from the Department of Defense. Because just like the subpoena for OMB, these documents from DOD speak directly to one of President Trump's abuses: his withholding of critical military aid from our partner Ukraine to further his personal political campaign. $250 million of taxpayer-funded military aid for Ukraine was managed by the Department of Defense as part of the Ukraine Security Assistance Initiative. These funds, approved by 87 senators in this very room, would purchase additional training, equipment, and advising to strengthen the capacity of Ukraine's armed forces. The equipment approved for Ukraine included sniper rifles, rocket-propelled grenade launchers, counter-artillery radar, night vision goggles, and medical supplies. And this equipment was to be purchased almost exclusively from American businesses. This equipment, along with the training and advising provided by DOD, was intended to protect our national security by helping our friend Ukraine fight against Vladimir Putin's Russia. Earlier, Counsel for the President tried to make the argument, well, it made it there. The aid eventually made it there. The delay doesn't really matter. And you heard me talk about why the delay does matter. But what Counsel for the President didn't say is that all of the aid has not made it there. Congress had to pass another law so that $35.2 million of that aid wouldn't expire and lapse. We did. But to this day, $18.5 million of that money remains outstanding and hasn't made its way to the battlefield. It was DOD that repeatedly advised the White House and OMB about the importance of the security assistance to not only Ukraine, but also U.S. national security. It was DOD in August of 2019 that warned OMB that the freeze was unlawful and that the funds could be lost as a result. And it was DOD that scrambled after the hold was lifted without explanation on September 11th to spend the funds before they expired at the end of the month. Without a doubt, DOD has key documents that the President has refused to turn over to Congress, key documents that go to the heart of the ways in which the President abused his power. It's time to subpoena those documents. DOD documents would provide insight into critical aspects of this hold. They would show the decision-making process and motivations behind President Trump's freeze. They would reveal the concerns expressed by DOD and OMB officials that the hold was violating the law. They would reveal our defense officials' grave concerns about the impact of the freeze on Ukraine and U.S. national security. They would show that senior Defense Department officials repeatedly attempted to convince President Trump to release the aid. In short, they would further establish the President's scheme to use our national defense funds to benefit his personal political campaign. We are not speculating about the existence of these documents, and we're not guessing about what they might show, because during the course of the investigation in the House, witnesses who testified before the committees identified multiple documents directly relevant to the impeachment inquiry that DOD continues to withhold. We know these documents exist, and we know that the only reason we do not have them is because the President himself directed the Pentagon not to produce them, because he knows what they would show. To demonstrate the significance of the DOD documents and the value they would provide in this trial, I would like to walk you through some of what we know exists, but that the Trump administration continues to refuse to turn over. And again, based on what is known from the testimony and the few documents that have been obtained through the public reporting and lawsuits, it's clear that the President is trying to hide this evidence because he is afraid of what it would show the American people. We know that DOD has documents that reveal that as early as June, the President was considering holding military aid for Ukraine. As I mentioned earlier, the President began questioning military aid to Ukraine in June of last year. The President's questions came days after DOD issued a press release on June 18th, announcing it would provide its $250 million portion of the aid to Ukraine. According to public reporting, Deputy Undersecretary of Defense Elaine McCusker, who manages the DOD's budget, learned about the President's questions. We know this email exists because in response to a Freedom of Information Act lawsuit, the Trump administration was forced to release a redacted email. But DOD provided none of those documents to the House. Deputy Assistant Secretary of Defense Laura Cooper and her team were tasked by the Secretary of Defense with responding to the President's questions about the Ukraine assistance. Ms. Cooper testified that she put those answers in an email and described those emails during her deposition. She testified that DOD advised the security assistance was crucial for both Ukraine and U.S. national security and had strong bipartisan support in Congress. But DOD provided none of those documents to the House. With this proposed amendment, the Senate has an opportunity to obtain and review the full record that could further demonstrate how and why the President was holding the aid. Laura Cooper also testified about the interagency meetings that occurred in late 2019, the meetings at which DOD was shocked to learn that President Trump had placed a mysterious hold on the security assistance. We know what happened at several of those meetings because Ms. Cooper participated in them, in some cases with other senior Defense Department officials. However, we don't have Laura Cooper's notes from those meetings. We don't have the email she sent to senior DOD officials reporting the stunning news about the President's hold. We don't have the emails that show the response from the Secretary of Defense and other senior defense officials because DOD has refused to provide them. Separately, Laura Cooper testified about when when Ukraine first learned of the president's secret hold on the military assistance. The same day as the president's July 25th call with President Zelensky, DoD officials received 2 emails from the State Department indicating that officials from the Ukrainian embassy and congressional staff had become aware of the hold and were starting to ask questions. Ms. Cooper testified that she was informed, quote, "The Ukrainian embassy and House Foreign Affairs Committee are asking about the military aid," end quote, and that the Hill knows about the FMS situation to an extent, and so does the Ukrainian embassy. All of this shows that people were starting to get very worried. Again, this amendment for a subpoena to DoD would compel the production of these important documents. But again, there is more. DoD documents would also reveal key facts about what happened on July 25th after OMB directed DoD to, quote, "hold off on any additional DoD obligations for the assistance to Ukraine." How did DoD officials react to OMB's directive to keep this order quiet? Did DoD officials raise immediate concerns about the legality of the hold? Concerns that they would eventually vocally articulate to OMB in August. Did DoD officials hear from the American businesses that were on tap to provide the equipment from Ukraine? Was DoD informed that the president's hold would undermine American jobs? Answers to those questions may be found in DoD emails, emails that we could all see if you issue the subpoena. Earlier, I mentioned that by late July, officials in our government raised significant concerns about the impact and the legality of President Trump's hold on the military aid. We know this from witness testimony, public reporting, and documents produced in Freedom of Information Act lawsuits. For example, at an interagency meeting on July 31st, Laura Cooper, one of the officials at DoD, announced that because there were 2 legally available options to continue the hold, and they did not have direction to pursue either of those legal options, DoD would have to start spending the funds on August 6th. Cooper explained that if they did not start spending the funds, they would risk violating the Impoundment Control Act. It was a fateful warning because that is exactly what happened. Throughout August, Pentagon officials grew increasingly concerned as the hold dragged on. According to public reporting, DoD wrote to OMB on August 9th to say that it could no longer claim the delay would have no effect on the Defense Department's ability to spend the funds. We only know this through recent reporting about the contents of the email. President Trump certainly hasn't made this information public. In response to a Freedom of Information Act request, the Trump administration released this August 9th email from Elaine McCusker, the Pentagon's chief budget officer. And as you can see from the slide in front of you, it is almost entirely blacked out. According to public reporting, the email said, quote, "As we discussed as of 12 August, we don't think we can agree that the pause will not preclude timely execution. We hope it won't, and we'll do all we can to execute once the policy decision is made, but can no longer make that declarative statement." Let me interpret what's actually being said here. What's actually being said is, we're in trouble. We can't spend the money in the time that we have left, and we're not going to cover your tracks anymore and say that we can't. The extensive redactions in the Freedom of Information Act productions highlight the administration's efforts to conceal the president's wrongdoing. They also underscore why the Senate must subpoena DoD documents to ensure that all of the relevant facts come to light. And yes, there is more. Based on the concerns expressed by McCusker and others at DoD, OMB eventually dropped from the documents the statement that the hold would not preclude timely execution of the funds. But OMB also circulated talking points claiming that, quote, no action has been taken by OMB that would preclude the obligation of these funds before the end of the fiscal year, end quote. Let me just explain what's going on here. Everybody is getting worried. Everybody knows that something bad is about to happen. Nobody has a good explanation. And nobody wants to be left holding the bag. So they're sending the emails, they're sending the memos to say, I told you so, and I'm not going to be held responsible. DOD's McCusker took issue with OMB's talking point. She did so in writing. Ms. McCusker emailed Mr. Duffy to tell him that OMB's talking points were, quote, just not accurate, and that DOD had been consistently conveying that point for weeks. Again, we know this from a press report, not from documents produced to Congress by the Trump administration. Now, President Trump did release some documents in response to a lawsuit under the Freedom of Information Act. But here is what Ms. McCusker's email looked like when it was released by the Trump administration. Her concern that OMB's talking point was, quote, just not accurate, was again entirely blacked out. What else is being hidden from the American people? The Senate should issue the subpoena. DOD documents would also shed light on OMB's actions as the president's scheme unraveled. On September 9th, Ms. McCusker informed Duffy that DOD could fall short of spending $120 million or more because of the hold. Duffy responded by suggesting that it would be DOD's fault if they ended up violating the Impoundment Control Act. McCusker responded, quote, you can't be serious. I am speechless, end quote. It will come as no surprise, then, that the administration entirely redacted this email, too, when it produced the documents in connection with the Freedom of Information Act lawsuit. Thanks to public reporting, though, we do know its contents. But what else is being hidden from the American people? What other reactions did this exchange set off within DOD? And were those concerns brought back to the White House? The Department of Defense's documents would shed light on these questions. The American people deserve answers. Make no mistake, the record before the House fully supports the conclusion that President Trump froze vital military aid to pressure Ukraine into helping the president's political campaign. The DOD documents would provide further evidence of this scheme. They would expose the full extent of the truth to Congress and the American people, and they would firmly rebut any notion that President Trump was acting based on concerns about corruption or other countries' contributions, and the president knows it. If there was any doubt, recent events prove that DOD has documents that are directly relevant to this trial. As I spoke about earlier, before I was a member of Congress, I was a soldier in Iraq and Afghanistan, and I do know what it feels like to not have the equipment that you need. The men and women who work at the Department of Defense and administer this vital aid understand that reality too. And that is why they repeatedly made the case to President Trump why military assistance to Ukraine is important. That it would not only help Ukraine, but also bolster our deterrence against further Russian aggression in Europe. Because every time we have these discussions that might seem abstract to people around the country, I do think about those 60,000 U.S. troops that we have in Europe, many of whom, by the way, are stationed there with their families, their spouses, their children, and how they're training and working every day to hold the line and fight for freedom and liberty in Europe. And if the war in Ukraine spills over outside of Ukraine, it is those men and women that will have to get into their tanks, in their helicopters, and do their job. The United States Senate cannot let this information remain hidden. It goes directly to one of President Trump's abuses of power, again, withholding aid that 87 people in this room already voted for. The President, the Senate, and the American people deserve a fair trial. Let's see the documents, and let's see them now, and let the facts speak for themselves. I would like to end by reading a short transcript, something that I was thinking about earlier this evening. This is a transcript from Ambassador Taylor's testimony. I just want to take a minute to read it to you. He was talking about a trip that he made to visit our friends in Ukraine. We had a meeting with the defense minister. It was the first meeting of the day. We went over there. They invited us to a ceremony that they have in front of their ministry every day. Every day they have this ceremony. And it's about a half an hour ceremony where soldiers in formation, the defense minister, families of soldiers who have been killed are all there. And the selection of which soldiers are honored, which soldiers who had been killed are honored, is on the date of it. So whatever today's date is, you know. If we were there today on the 22nd of October, the families of those soldiers who were killed on any 22nd of October in the previous 5 years would be there. End quote. Ambassador Taylor was talking about our friends. At least 13,000 of them have given their lives in the last 5 years in the fight for liberty in Europe. This, ladies and gentlemen, is a national disgrace. And only the people in this room can fix it. It's time to issue the subpoenas. Mr. Chief Justice, the House managers reserve the balance of our time for an opportunity to respond to the President's argument.
Mr. Cipollone?
Mr. Chief Justice, Mr. Philbin will make this argument.
Thank you.
Mr. Chief Justice, members of the Senate, I will be brief. And this may seem like some deja vu all over again because we've been arguing about the same issues really over and over and over for a long time. And I think that's something that Americans one of the things they don't really understand about Washington is how it could be the House Democrats think that it is the best use of time for this body to spend an entire day deciding simply the issue of when this body should decide about whether or not there should be witnesses and documents subpoenaed, because that is the issue before the body now. It is not the question finally of whether there should be witnesses or documents. As the majority leader has made clear multiple times, the underlying resolution simply allows that issue to be addressed a week from now. The only question at issue now, and the House managers keep saying, how can you have a trial without witnesses? How can you have a trial without documents? That's not even the issue. The issue is only now whether you have to decide that issue to subpoena documents or witnesses now or decide it in a week after you hear the presentations. Why are they so eager to have you buy a pig in a poke? Why is it necessary to make that decision without having more information? In the Clinton trial, this body agreed 100-0 that it made more sense to have more information and then decide how to proceed. That it was rational to have more information to hear the presentations and then decide what more was necessary. Why is it so important that you've got to make that decision now without that information? That doesn't make any sense. The rational thing to do is to hear what sort of case they present and, importantly, to hear the President's defense, because the President had no opportunity in the House to present any defense. We've heard a lot about the rule of law and about precedent. What was unprecedented was the process that was used in the House, a process that began with an impeachment inquiry that started without any vote by the House. And this is a point I made earlier. The Constitution assigns the sole power of impeachment to the House, not to any single member of the House. So the press conference that Speaker Pelosi held on September 24th did not validly initiate an impeachment inquiry, nor did it validly give power to committees to issue subpoenas. So we're talking now about the DOD documents. What efforts did they make in their proceeding to get these documents? They issued one invalid subpoena, totally unauthorized under the Constitution. It was unprecedented because it was issued in an impeachment inquiry, purportedly, without any vote from the House. Never happened before in our history in a presidential impeachment. It was unlawful. It was unauthorized. And that's why no documents were produced, and they made no other efforts to pursue that. So we've heard a lot about the rule of law. The rule of law applies to the House Democrats as well, and they didn't abide by it. It was unprecedented to have a process in which the president had no opportunity to present his defense, no opportunity to present witnesses, no opportunity to be represented by counsel, no opportunity to present evidence whatsoever in 3 rounds of hearings. And they'll mention, oh, in the Judiciary Committee, they were willing to give the president rights. But in the Judiciary Committee, after one hearing, the Speaker announced the conclusion that articles were going to be drafted, and the committee had already decided it would hear no fact witnesses. There were no rights for the president. So it makes sense, what's rational, what 100 senators 21 years ago thought was rational, was to hear the case that can be presented on the record established so far, and then decide if something else needs to be done. Let the president make his case. We're ready to get this started. The House manager should be as well. Thank you, Mr. Chief Justice.
Mr. Chief Justice,
Cipollone.
we yield the balance of our time.
Thank you. House managers have 38 minutes remaining.
Mr. Chief Justice, I will be brief. Counsel for the President continues to say a lot of things that just really rub me the wrong way. He says, you know, we're talking and saying the same argument over and over and over again. Well, I'm ready to keep going because this is an important debate, and we need to have it now. He also said something about what the American people don't understand about Washington. Well, I haven't been here very long, and I can tell you I don't think the American people care very much about whether or not people in Washington, you know, are sitting around debating all the time and thinking about, you know, what you're concerned about right now. What they are concerned about is whether or not their government is working for them, whether or not there's corruption in their government. That's what they understand. And that's what this debate is about. Counsel for the President said, why now? Why the information now? The better question is, why not now? This trial has started. Let's have the facts and information now. Ladies and gentlemen, the time is right. There's no reason why we shouldn't issue those subpoenas, get the facts, get the testimony, have the debate, let the American people see what's really going on here. Mr. Chief Justice, I will yield the balance of my time to Mr. Schiff.
Thank you.
Senators, I'll be brief, but I do want to respond to a couple of the points that my colleagues have made. First is the argument that you've heard before, and I have no doubt you'll hear again, that the subpoenas issued by the House are invalid. Well, that's really wonderful. I imagine when you issue subpoenas, they will declare yours invalid as well. What's the basis of the claim they're invalid? Well, because they weren't issued the way the president wants. Part of the argument is you have to issue a subpoena the way we say, and that can only be done after there is a resolution that we approve of adopted by the full House. First, they complained there was no resolution, no formal resolution of the impeachment inquiry, and then when we passed a formal resolution, they complained about that. They complained when we didn't have one, they complained when we did have one. Well, you know, they made that argument already in court, and they lost. In the McGahn case, they similarly argued this subpoena for Mr. McGahn is invalid. And you know what the judge said? Essentially, that's nonsense. The president doesn't get to decide how the House conducts an impeachment proceeding. The president doesn't get to decide whether a subpoena it issues is it valid or invalid. No, the House gets to decide, because the House is given the sole power of impeachment, not the President of the United States. Now, counsel says, why are we going through all these documents? Aren't all these motions the same? And the fact of the matter is, we're not talking about the same documents here. They would like nothing better than for you to know nothing about the documents we seek. They don't want you to know what Defense Department documents they're withholding. Yeah, of course they don't want to hear that. They don't want you to know what State Department documents are they, because if it's just abstract, if it's just we're here arguing for documents, well, they can say, well, that's really not that important, right? It's just some generic thing. But when you learn, as you have learned today and tonight, what those documents are, when you see the efforts to conceal those Freedom of Information Act emails that my colleague Mr. Crow just referred to, and you see what was released to the public, and it's all redacted, and we find out what's under those redactions, and wow, surprise, it's incriminating information they have redacted out. That is not supposed to be the basis for redaction